Hello and welcome to Shikara Academy's UPSC Mains PYQ series. So continuing this series, we will be discussing all the previous year's GS Mains questions asked by UPSC from the year 2013 to 2024. So in this third session, we will be discussing five Mains PYQs from asked in last year, that is 2024 General Studies Paper 2. Now, in 2024 General Studies Paper 2, the question 11 was that what are the aims and objectives of the recently passed and enforced the Public Examination Prevention of Unfair Means Act 2024? Whether university state education board examinations too were covered under this act. A 15-mark question that has to be answered in 250 words. So this particular question was solely based on current affairs or the current affairs of the last year, because last year there were many cases of the leaking of question papers. The NEET paper was compromised, the NEET UG paper was compromised, and many of the Public Service Commission examinations were also compromised. That is why the government has came up with the Public Examination Prevention of Unfair Means Act of 2024. Now the question is asking about its important aims and objectives, and whether the university and the state board examinations are under this act or under the preview of this act or not. So mapping it with the syllabus, it has come under the syllabus of uh, the subject of governance. That is the important aspect of governance, transparency and accountability. So it is mainly focusing on transparency and accountability. Now the approach that we will be taking is the introduction body conclusion approach. In introduction, we will be describing this Public Examination Prevention of uh, Unfair Means Act of 2024. So here we describe the act, we introduce the act. Then in the body, we address the demand of the question by writing the aims and objectives of the act and what are the key features of this act. Then in conclusion, we write the overall significance of the act, like why it was introduced and what do we aim to achieve with this act. Now, in introduction, in light of the growing concerns over frequent exam paper leaks and malpractices, the Indian Parliament enacted the Public Examination Prevention of Unfair Means Act of 2024. Okay, that was the backdrop in which the act has been enacted. It is a comprehensive legislative measure to safeguard the integrity of the public examinations and ensure transparency, accountability, and fairness in recruitment as well as in educational assessments. So, recruitments in the case of the Public Service Commission examination or the employment examinations, and also for the educational entrance test also. Now, the main aims and objectives of the Act are to prevent the unfair means, to curb the unfair practices such as the paper leaks, the impersonation, and tampering, as well as cheating in the public examination. So these are the four issues in which grapple our uh, public examination system. First is the rampant paper leaks, the impersonation, some other person is appearing in the paper, tampering of the answer sheets, and the cheating inside the examination hall. Second aim objective is to ensure accountability, to hold accountable the individual and institutions that are involved in examination related misconduct. So all the individuals as well as the institutions which are involved in the misconduct of the examination will be punished under the act. Very important to safeguard the aspirant's interest. Now to protect the efforts of and aspirations of the genuine candidates appearing in the competitive examinations, because of these rampant cases of paper leaks, impersonation, and unfair means and practices, the the serious aspirants, the candidates, the sincere candidates, they feel dejected and demotivated. Fourth is the to strengthen the overall examination ecosystem in the country, to ensure, to reinforce the institutional mechanisms to secure credible and tamper-proof conduct of examinations, which are very important in the country to um, applaud the merit. Then the key features of the Act, the definition of offences. So this Act has defined what is a paper leak, the unauthorized access to exam systems, impersonation, and organized cheating. So what constitutes a paper leak? what constitutes an organized cheating, what constitutes an impersonation. So all these terms have been defined in the Act. Then the Act mentions the punishment. It provides imprisonment up to 10 years and up to a fine of 1 crore for the offenders. So both the provision of fine as well as the jail time is in the punishment. Then organized crime provision. Higher penalties for organized crime syndicates involved in the examination frauds. Then special courts, establishment of fast track courts for time bound trial and justice delivery, because in the normal judicial things, if things go with a normal judicial pace, it takes years for such cases to get resolved. And the aspirants or the youth's prime time in their 20s or late teens, it get wasted. Then there is investigative powers. It authorizes the law enforcement to investigate offences as cognizable and non-bayable offences. Then what are the coverages under? So it covers the examination, recruitment examinations conducted by UPSC, the SSC or the Staff Selection Commission, the Railway Recruitment Board, etc., and the entrance tests such as NEET, JEE, CUET. But it excludes the university examinations as well as the board examination. So there is exclusion of the university and state board examination. University exams and state education board exams are not covered under the Act. These fall under the jurisdiction of respective state governments. Okay, so that is why the center's jurisdiction is not there. So this Act excludes the university exam as well as the state board examinations. Now, in conclusion, we write the significance of this Act. Okay, what we can achieve with this Act. So, this Public Examination Act of 2024 is a timely and robust measure to restore public trust in India's examination system. Okay, by deterring the malpractices and ensuring strict penalties, the Act protects meritocracy as well as it upholds the sanctity of the competitive exam. So, this meritocracy is the keyword here, and the sanctity of the competitive exams is also a key phrase. Although it does not currently extend to the university or state board examinations. Okay, so it is mainly for the entrance and the recruitment examinations are currently under this Act. Then moving on to the next question, question 12 of the last year's General Studies paper 2. That is, the right to privacy is intrinsic to life and personal liberty and is inherently protected under Article 21 of the Constitution. So nothing is asked in this statement. This is just an introductory statement to the question. Now, our approach to deal with the introductory line is we will be dealing with the introductory line in the introduction of the answer itself. So we have to explain this line. In this reference, we have to also discuss the law relating to the DNA testing of child in the womb to establish its paternity. So this DNA testing of a child, whether it violates the right to privacy of the couple or of the child, that we have to analyze, that we have to discuss. A 15-mark question that we should be answering in 250 words. It's quite an application or applied base. So in this type of question needs utmost conceptual clarity, okay, in order to write the answers. Mapping it with the syllabus. So it is mainly from the governance, that is government policies and interventions. And also from the polity part, because it has been asking about the right to privacy. Now, seeing the approach, so we have got an introductory line. So in introduction, we will be dealing with the introductory line and describe the right to privacy. Then in body, we write about the right to privacy in Article 21, as it was asked in the question. Then we answer about the DNA testing and the paternity laws. Then in conclusion, we write a forward-looking conclusion or a way forward. Now, in introduction, the right to privacy is a fundamental right under Article 21 of the Indian Constitution, which guarantees the protection of life and personal liberty. The landmark Justice K.S. Puttaswamy versus Union of India case of 2017 judgment affirmed this privacy law, affirmed that the privacy is intrinsic to human dignity. So This Puttaswamy judgment has linked the privacy with the human dignity. The right becomes critical in sensitive issues like DNA testing of child in the womb of paternity determination. So this way we have connected the two things that were asked in the question itself. Now writing about the body, the right to privacy in Article 21. So the right to privacy has a constitutional backing. The Article 21 ensures that no person shall be deprived of life and personal liberty except in accordance to procedure that is established by the law. It has an expanded scope that it includes the right to bodily autonomy, reproductive choices, as well as informational privacy. So, informational privacy, the reproductive choice, as well as the body's autonomy, choice over body's autonomy, uh, all is included in this Article 21, that is right to life and personal liberty. The Puttaswamy judgment of 2017 recognized privacy as part of the basic structure of the Constitution. And this is under Article 21. Now, discussing the DNA testing and the paternity laws. So, DNA testing as intrusion. The forced DNA testing, especially of a fetus, is considered as invasions of the mother's bodily integrity and privacy. So, if we are forcefully testing the DNA of the baby, then that is an invasion to the mother's body integrity because mother is carrying the fetus of the child and her privacy. Supreme Court had certain guidelines on this. Courts have ruled that DNA tests cannot be directed routinely and must be ordered only when they serves the cause of justice. So it is not a common practice to carry out the DNA testing. Only in some extreme cases or in the cases as and when required, the permission of DNA testing is given. In Gautam Kundu versus State of West Bengal judgment 1993, the Supreme Court held that the DNA testing should not override the right to privacy unless necessary. Okay. So DNA testing should not override the right of privacy. The right of privacy is dominant over the DNA testing. Then there are medical as well as ethical concerns. So DNA testing of a fetus can carry medical risks and must adhere to the ethical guidelines laid down by the Medical Council of India and the PCPNDT Act, the Prenatal Diagnostic Act. Okay. Now, in conclusion, we write a way forward or a forward-looking conclusion. We write that while DNA testing may serve legal and evidentiary purposes, it must be balanced with the right to privacy and bodily autonomy. So there should be a balance between this DNA testing as well as right to privacy and a body's autonomy for one's body, especially of the pregnant women. The courts have emphasized that such testing should be ordered sparingly, ensuring it does not violate the dignity and rights protected under the Article 21. So this bodily autonomy as well as the right to privacy is protected under Article 21 of the Constitution. Thus, legal interventions must weigh the need of truth against the constitutional guarantee of privacy. Now, we move on to the next question. The 2024 GS Paper 2, question number 13. So, what changes has the union government recently introduced in the domain of center-state relations? So, it is a question on center-state relation. Now, we also have to suggest measures to be adopted to build the trust between center and the states for strengthening federalism. So, this is a question on federalism, that is center-state relation. A 15-mark question, direct polity question that has to be answered in 250 words. So, it is a current affairs based polity question. Okay, mapping it with the syllabus, we see it has been asked from the subject of polity, issues and challenges pertaining to the federal structure. So we have to describe the changes that the union government has recently introduced, as well as we have to give our own suggestions. We have to provide the suggestions, the measures, so that the trust between the center and state enhances, and this trust ultimately strengthens the federal structure in the country or federalism in the country. In introduction, we describe the central state relations. In body, we write about what recent changes that has been introduced by the central government or the union government, and right in the body itself we write the measures to build the trust and strengthen federalism. So this is here we address the demand of the question, because the question is asking us only two things: the recent changes as well as measures. Then in conclusion, we have provided the measures, so we write a way forward. Now, describing the center-state relation. So, India's federal structure is characterized by a strong center and constitutionally empowered states. So, this is the model of federalism in the country. However, over time, the balance has often tilted in favor of the union. That thing is observed. In recent years, several developments have influenced the center-state relations, prompting debates on the need of strengthening the cooperative federalism. So, cooperative federalism here is the keyword. Okay, so we have described the federalism as well as the center-state relations, like the trend of center-state relations in India. Then we write the body, that is the recent changes introduced by the union government. So first is the legislative overreach. The passage of the central laws is a in subjects under the state law. So in 2020-21, the government passed the farm laws. So farm or agriculture is under the state list, but the union government or the central government has made law. So that was quite an overreach. And there was also inadequate consultation. Then there is reduction in fiscal autonomy. So there is delay in GST compensation to states. So after the implementation of GST regime in indirect taxes, so there has been a delay in GST compensation. The compensation says that has been given and that has to be provided under the GST regime. There is increased central control on fiscal transfer via the centrally sponsored scheme. So government is coming up with more and more centrally sponsored scheme, and in centrally sponsored scheme there is a tighter uh, fiscal angle. The fiscal transfers from the central government is delayed. Then there is use of central agencies. There are allegations of misuse of the ED, CBI, and IA, raising concerns about the political neutrality, especially in the states that are governed by or that are ruled by the political parties that are not a part of the government in the center. Then there is governor's role. There is very much interference by the governors. So the governors, they feel empowered and they try to block the legislative happenings or the proceedings that are taking place in especially the opposition ruled states. So governors they interfere in the state administration and they delay in giving their assets to the state bills. Then there is digital centralization. The launch of centrally managed digital platforms for schemes such as PM Vani, the National Digital Health Mission, without the state inputs. So digitally there is centralization, financially there is centralization, administratively there is centralization by the appointment of governors. So overall, the changes that we are seeing or the changes that the union government is introducing is more towards centralization. And this is overall is this is detrimental to the federal structure of the country. So what measures can the government take in order to build the trust between the center and the states, so that the federalism it strengthens in the country? So we have to strengthen the interstate councils. Regular meeting and genuine policy dialogues should be there between the interstate councils that we have. Second, there is fiscal federalism, because there should be timely release of funds, greater flexibility in scheme design, and review of the GST structure. The entire GST structure, there is a need to review that in order to strengthen the fiscal federalism in the country. Then there is transparent role of governors. The governors should have a limited power, so limit the discretionary powers and ensure the impartial conduct of the governors. That is very important. Then there is legal clarity on jurisdiction. There should not be legislative encroachment. So central should not encroach on the legislative field of the states. Central should consult the states before enacting any of the national laws. And there should be promotion of cooperative federalism. The It encourages the cooperative federalism, encourages the central state collaboration in policy making and as well as execution. So even at the policy formulation stage as well as the policy execution stage, there should be a collaboration between the center as well as the state governments. This will improve the this this is the cooperative federalism which will eventually improve the trust and the federalism in the country. So now we give a way forward that by strengthening the center state relations is essential for India's unity and democratic health. Okay. A shift towards a consultative, cooperative, constitutionally respectful federalism can ensure the balanced governance. What we can achieve with the federalism is a balanced governance and foster mutual trust between the union as well as the states. So moving on to the next question, that is question 14 of 2024 General Studies Paper 2. Explain the reasons for growth in the public interest litigation in India. So it is a question on PIL. So as a result of increased growth in public interest litigation, so the question is not asking whether there has been an increase or decrease. So the question has given that there has been an increase in the number of there has been a growth in the public interest litigation in India, and we have to give the reasons. Now, what are the reasons why the number of PILs they are keep on increasing? Then, as a result of it, has the Indian Supreme Court emerged the world's most powerful judiciary? So, we have to analyze whether because of the increasing number of PILs, in growth in the number of PILs, so Supreme Court, whether or not it has become the most powerful judicial institution in the entire world. So, it is a 15-mark question, application of the conceptual based question that has to be answered in 250 words. So mapping it with the syllabus, we have seen that it has been asked from the subject of polity, that is the judiciary. It is asking about both the PIL as well as the Supreme Court's jurisdiction. Now the approach that we will be taking in introduction, we will be describing what a PIL is. Okay. Then in the body, we address the demand of the question by writing the reasons for the growth of PIL in India because we were asked the reasons. Then we write the Supreme Court as the world's most powerful judiciary that we have to analyze. And then in conclusion, we either summarize the entire answer or we give the significance of the PILs. Now, writing the introduction by beginning that we described PIL, public interest litigation, PIL in India emerged as a powerful judicial tool. So, it is a powerful judicial tool in the late 1970s and 80s. So, the PIL emerged as a powerful judicial tool in late 1970s as well as early 1980s. It aims to democratize the access to justice. The aim of PIL is to democratize the access to justice. It allows any public spirited individual or organization to approach the courts on the behalf of those whose rights are denied. So if you think that some other person's or has been denied, then you can approach, then you as an individual without any locus standi, you can go and approach the court and file an PIL. Over time, the PIL have not only empowered the marginalized, but have also reshaped the role of Indian Supreme Court. So, two observations have been that we have seen or that we can make with this increased PIL. First is it is leading to the empowerment of the marginalized sections of the society or the marginalized or the people. Secondly, the judiciary itself, the Supreme Court itself, it its role has been reshaped and it is becoming all the more powerful. So, writing the body, we address the demand of question by writing the reasons for growth in of PIL in India. First is the liberalization of locus standi. So, locus standi is a principle, judicial principle. The Supreme Court has allowed individuals not directly affected to file the PILs, making the justice more accessible. So, even if you do not have a locus standi or if the overall case has no bearing, has no impact on you, Then also that particular individual or you as an individual can file a PIL if you feel some other person's rights have been compromised or violated. So that this has made the access to justice more uh, available. Second is the judicial activism. So judiciary stepped in to fill governance gap. Over the years, we have seen there has been cases of judicial activism and sometimes we even the cases of judicial overreach, especially in the environmental protection, the human rights, as well as the corruption. Then there are socio-economic injustices. There is widespread poverty, illiteracy, unawareness. There is state apathy has triggered the public interest concerns. So all these factors such as the poverty, the illiteracy, and the state's apathy towards the marginalized people have triggered the public spirited individuals to file more and more PILs, and they are taking the routes of judiciary in order to get their work done. Then there is media and civil society. Increased awareness and activism led to PILs in various issues like the bonded labors, the pollution, the environmental issues, as well as the gender rights. Now, discussing about the landmark cases, so the Husainara Khatun case, the MC Mehta case, the Vishaka case, they set the strong precedents for the public rights via PIL. So, in these PIL cases, the Supreme Court has laid down certain guidelines. Supreme Court has gave out certain important judgments, and it has such become the precedent. Now, had this PIL made the Supreme Court a very powerful institution, the most powerful judiciary in the entire world. The Supreme Court holds a unique position globally due to the suo motu powers to initiate cases. Supreme Court in India can initiate the cases suo motu, that is, on their own. Then there is power of judicial review and striking down the laws. The Supreme Court it has the power of judicial review and can strike down the laws enacted by both the state as well as the union government. Then there is expansive interpretation of the fundamental rights under Article 21 that we have just seen in the Puttaswamy judgment. Also, the Supreme Court has interpreted the Article 21 in a very wide way and it has come out with the right to privacy. Similarly, it has also come out with the right to education in the Article 21 itself. So, Supreme Court's intervention have shaped the public policy and executive accountability unmatched in the many democracies around the world. So, our Supreme Court is indeed very powerful as compared to the judiciaries of the other democratic countries. So, in conclusion, either we can summarize the entire answer or we can give the significance of the PIL. So, PILs have transformed Indian democracy by bringing justice to the doorstep of the common man. So, it has democratized. So, this PIL has democratized the process of justice delivery to the doorstep of the common man. It has democratized the justice or judiciary. In doing so, this PIL have elevated the Indian Supreme Court to one of the most proactive and powerful judiciaries in the world and acting as a guardian to the constitutional morality and the constitutional rights. So this is the significance of PILs. Now moving on to the last question of the day, the question 15 of the UPSC Mains paper, GS paper 2, 2024. Discuss India as a secular state and compare the secular principles of the compare with the secular principles of the US Constitution. Now, this particular question, if you have done the PYQs very well, so this secularism, the question on Indian secularism is repeated very frequently in the examination. Okay. So every 2 or 3 years, you will find the question that is based on the secularism of the and as well as we have to compare. So either comparing of the secularism with USA or with some other country like France or some other Western European countries. So this is very common question. Okay. And over if you pick up the question paper of the last 10 years, at least 2 or 3 times you must be finding this type of question in the exact question on the secularism in India and comparing the secularism of India with some other country. Now, mapping it with the syllabus, so it is a 15-mark question asked for 250 words. Mapping it with the syllabus, it has been asked from the subject of polity, that is Indian Constitution, features and significant provisions, that is the secularism as a significant provision. Now, in approach, we describe the secularism, like what is our basic understanding of secularism is. Then in body, we address the demand of the question by writing about India as a secular state and secularism in the US Constitution. And in conclusion, we summarize the entire answer. So, in introduction, we write what, in introduction, we will be writing what the examiner might find in the body, what the examiner expects in the body. Then in body, we address the demand of the question. And in conclusion, we again write what we have actually written in the body, but in a very precise or brief manner. Now, the secularism, the definition or describing the secularism refers to the separation of religion from the state. So, this is the straightforward classic definition of secularism. It ensures equal treatment of all religions by the government. So, it is the separation of religion from the state, and what it ensures the equal treatment of all religions by the government. India and United States, though both are secular democracies, they interpret and implement secularism differently based on their unique historical as well as cultural context. So, Indian idea of secularism is different from the Western idea of the secularism. Now, we substantiate by writing about India as a secular state. So, we have the constitutional provision. The word secular was added to the preamble by the 42nd Amendment Act in 1976. So, the word secular is in the Constitution's preamble. Then, Article 25 to Article 28 in the Part 3, that is fundamental rights of the Constitution, guarantees the freedom of religion, including the right to profess, practice, and propagates one's religion or the faith. Then there is principle of equal respect. So India follows the principle equidistance, that is recognizing and respecting all religions. So we are not separating the religion. We recognize all religions and we respect all religions without any preference to a particular religion. Then there is state intervention. The Indian state, that is the Republic of India, can regulate religious practices for social reforms. So we have also abolished the untouchability and the triple talaq verdict or the triple talaq judgment and the triple talaq the act. They are a testament to that the state can intervene in the religious practices in order to carry out the social reforms in the society. Then there is cultural pluralism. That is, the Indian secularism promotes the positive engagement between the state and the religion. So there is a positive. So Indian secularism, we call it positive secularism because it encourages, it promotes the positive engagement between the state and the religion. It is not dehyphenating the state with the religion. So in India, the government respects the multi-religious characters of the society. That is the positive aspect of secularism or positive way of secularism. Then comparing with the secularism in the US Constitution. So in US there is a wall of separation doctrine. That is, in the very first amendment of the US Constitution, prohibits the establishment of religion and guarantees the free exercise. So in US there is a In the Western world, there is a negative connotation to this idea of secularism, that is the complete wall or complete separation of the religion and the state. Then there is strict church and state separation, because US is predominantly a Christian country, a Christian nation. Their president also takes the oath over the Bible. So but even though there is a separation between, even though such religious practices are there in their government, but there has been a strict separation of church from the state. The US follows a very strict separation model with minimal state involvement in the religious matters. Okay, so no religious symbols in the state affairs. The state cannot fund or endorse any religious activity. Unlike India, we encourage and support the religious activities of different religions. Okay, the government gives this Hajj subsidy. The government also promotes the pujas in the on the Hindu festivals, or the government promotes the Sikh pilgrimage to the sites in Pakistan. So these are the different uh, positive way, or positive in affirmative way. The government of India promotes all the religions equally, but in US there is no religious symbol in the state affairs. So state has no affair in the church, and church has no affairs in the state. Then, in summary, we can write that while both India and US uphold secularism, India adopts a multi-faith inclusive model, allowing the state engagement for reform and equality, whereas the US follows a non-interventionist approach. So, in India, we have an inclusive approach, an interventionist approach, and in US, there is a non-interventionist approach. These distinct secular frameworks reflect the societal realities and democratic values in the respective nations, because their idea of democracy and religion has come up uh, with the structure of their own society, and our idea of religion, our idea of secularism has evolved from our own, the evolution of our own society. So the PDF of these model answers will be available to you on Shikara Academy